Hi, Mike Brantley, auctioneer. Auctioneers deal with contracts all the time, and I discussed in a couple other videos the concept of meeting of the minds, mutual assent. Both parties understand what's going on. They know what kind of deal or arrangement or agreement they're entering into in sufficient detail to contract. But that's not the only thing that a contract requires. So let's go over the basics. I hold there's three very basic ingredients to a valid contract. First of all, we have to have competent parties. Competent. And the opposite of competent is incompetent. So you're either competent or you're not competent. And here in the United States, once you're 18, you are considered legally competent, and you're competent until you're not at some point. And so competence, generally speaking, overall indicates a right mind or cognizant of the details of what's going on. You're taking your medicine, you're getting around, you're taking care of yourself. Competence is not dementia. It's not forgetting your car keys. It's not knowing where you're parked. It is a legal definition. Probate courts, largely across the United States, determine and handle and facilitate someone becoming incompetent, with doctors interceding and evaluating and report to the probate court, yeah, we believe this person is mentally incompetent. Then a guardian is oftentimes appointed to care for them. But as long as the people contracting are 18 and not incompetent, you have competent parties. Number two, consideration. There are two types of consideration: good consideration and valuable consideration. You don't necessarily need one or the other, but you've got to have some sort of consideration. What consideration is something of value. Could be money, could be property, could be love, affection, friendship, any of those types of things where someone would value that consideration. And in a contract, for the most part, you need both parties providing the other some sort of consideration. Third, you need mutual assent or a meeting of the minds. People have to be on the same page, understand what they're doing, understand the arrangement, agreement that they're entering into. So, competent parties, consideration, meeting of the minds. Obviously, contracts have to have a legal purpose, and largely that's not an issue with auctioneers, but as long as they have bidders who are at least 18 and not incompetent, understand the, for example, terms, conditions, or understand the bid calling, or understand the online platform, accepting bids and that kind of stuff that they understand. And consideration is almost an assumption, is that when I'm bidding at auction, for example, if I'm a bidder, what am I getting? I'm getting the property. What is the other party getting? They're getting my money to pay for the property. So there's consideration passing between the parties. When do auctioneers encounter these contracts? Well, basically three places. Number one, an auctioneer starts with contracting with a seller or a client. And that contract's between the owner slash seller and the auctioneer, authorizing the auctioneer to act on the seller's behalf to carry out certain duties, such as marketing, pickup, identification, etc., accepting bids, that type of thing. Largely because most of the public doesn't want to do that themselves, so they hire an agent, an auctioneer, to handle those duties. So there's a contract there. Bidders register. When they want to participate in an auction, they are often asked to agree to the terms and conditions of the auction, and that agreement often involves a signature, initial, or an acknowledgement that they agree to be bound by those terms and conditions. And so there's a contract there between the auctioneer and the bidder, allowing them to bid. What's the consideration? Well, if you agree to these terms, I am enriched by your participation. You're enriched by the right you have to bid. And then third, auctioneers in bid calling or online platforms that emulate bid calling. They serve to enter into contracts every time a bid is placed. So if I say start me out at $200 and somebody bids 25 to kick it off, I've got 25 and now 30. I have a bid at $25. I have a contract at $25. I've got competent parties, I've got consideration, and I have a meeting of the minds. I'm asking 30. I can get out of that contract by getting 30. That's one of the ways the auctioneer can get out of that contract. The bidder can get out by retracting their bid. The auctioneer can get out by getting a higher bid. If I get 30, I've got a new contract. I've got competent parties, I've got consideration, I've got a meeting of the minds, and I'm going to ask for 35. I can get out of that $30 contract with a higher bid of 35, for example, and the bidder at the moment at $30 can retract their bid. They can get out, I can get out. It's fair, it's equitable, it's reasonable. At some point, when I have $175 and can't get 200 sold, I say sold, auctioneers do, for $175, and I have a contract now, a slightly different contract, in that I can't take a higher bid, nor can the high bidder retract their bid. Now, there's a slight allowance in state law that allows auctioneers to reopen bids. We talked about the imprudence of that, the unnecessarily complexity of reopening the bid, and it's not necessary. And if you're a skilled bid caller, you don't have to reopen the bid. That's just a matter of the facts. I mean, if you know what you're doing, you identify who's on, you're clear, precise, you work with your ringman, you don't have to reopen the bid. So let's just leave that there and talk about that when you say sold, you've got a contract in place between the highest bidder and the seller. The auctioneer is acting as the agent. So you got contracts between the auctioneer and the seller. We've got contracts between the auctioneer and the bidder. And when the auctioneer says sold, we have contract between the high bidder, the buyer at this moment, and the seller, between the buyer and seller. And all of those contracts have to have competent parties, consideration, a meeting of the minds, and they often do. So auctioneers should endeavor to understand what contracts are and what contracts aren't, what you need for a contract, particularly the competent parties, because if you're sitting down with someone who's incompetent or underage, that contract can be voidable or possibly even void. And so careful. Meeting of the minds is another issue that, golly, we struggle with, because print keeps getting smaller, terms and conditions get longer, contracts get longer, and we've all been trained by the internet and by updating our portable electronic devices, or anything else for that matter, to do what? Well, you get 175 pages of 6-point type terms and conditions. If you want to use this device, hit OK. Or if you want to bid on this site, hit OK. What's everybody do? They just hit OK. Is there a meeting of the minds? Probably not. Probably not. But we've got a lot ahead of us in terms of the courts catching up to contracts where one party just agrees without reading, without understanding. And is that a meeting of the minds? To be determined, largely. And do we have consideration? Of course, that's the easy one. I'm going to pay money, I get the property. I'm going to pay you money, I get the property, that type of thing. Hopefully this helps you as an auctioneer understand how contracts work, what contracts are, what you need if you think you have a contract, what do contracts require. Mike Brantley, Auctioneer. Pleasure to be with you today. Other videos on this same page and others forthcoming. Have a great day and stay safe.